He's gonna go over all the paperwork, go over how to fill it out.
Okay, good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this morning for what we call an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies or misdemeanors. Now, your felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offense. Does not mean that they're not serious, it just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can get if they are found guilty of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. The person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary. Now, if a person is convicted of a capital murder, which is the highest felony offense in the state of Texas, then the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those type of punishment because, as I mentioned to you earlier, the offense that you have in this court is a misdemeanor case. Now, misdemeanors are divided into 3 categories. We'll start at the top, work our way up down to the bottom. We have the Class A misdemeanor, Class B misdemeanor, and the Class C misdemeanor. Now, if a person is convicted of a Class C misdemeanor, now, the range of punishment is by fine only. The fine cannot be above or cannot exceed $500. Now, Class C misdemeanors are cases that start or originate in the JP court or the city court. For example, a speeding ticket is a Class C misdemeanor. Not having your seatbelt on, having an expired sticker, those are Class C misdemeanors. Those cases come to this court when a person is either found guilty, plead guilty, or plead no contest, and they have a conviction in the JP court or the city court, and then they appeal their case. In essence, they want a new trial. And they get a hold of the trial. The case comes to this court. The punishment range does not change. It stays the same, which means that it's fine only, and the fine cannot be above $500. Now, the next highest misdemeanor is a Class B misdemeanor. With the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, or you could be given a fine that does not exceed $2,000. Or you could be given both such jail time and a fine. Now, the highest misdemeanor is a Class A misdemeanor. The range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days, which is a year, in the county jail. Or you could be given a fine that does not exceed $4,000. Or you could be given both such jail time and a fine. Now, you may be eligible for probation. There are 2 types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation. The other type is called adjudicated probation. Now, the difference between the 2 is as follows. With unadjudicated probation, it does not result in a conviction in your record. And if you successfully complete it, you will not have a conviction on your record. And you may qualify for non-disclosure, which means that your record will be sealed to the general public. So, for example, let's say you get a non-disclosure. Say you get deferred, you complete it, you get a non-disclosure, you apply to a job at ExxonMobil. ExxonMobil does a criminal background check, guess what? The record is sealed, they cannot see that case that you received unadjudicated probation. Now, the operative word is general public. ExxonMobil is part of the general public now, the police department, and certain government agencies that are listed in the Texas Code of Criminal Procedure can have access, but most of the public is the general public. They cannot have access to your record if you have a non-disclosure. Now, the next type of probation is called adjudicated probation. We have unadjudicated probation, now we have adjudicated probation. With adjudicated probation, it does result in conviction and record. However, there's something that is called judicial clemency. What that means is the court or the judge has the discretion to set your conviction aside. In essence, you would no longer have a conviction. Now, in order to qualify for judicial clemency, three things has to happen. One, you have to successfully complete probation. Two, there cannot be any more time left on the probation. And three, you have to be successfully discharged or let off the probation by the probation department. If those three things happen, then the court has the discretion to set aside your conviction. Now, however, if you get a subsequent conviction, that is, if you get another conviction later on after you receive judicial clemency on this case, then the case that you receive judicial clemency on can be resurrected. It can be brought back up. It can be revived. It can be used against you. And if you try to get a license with Child Protective Services, they can either deny giving you a license or they can revoke or suspend your license. Now, everyone here, for arraignment, you should have a clipboard. Who does not have a clipboard? You don't have one? Okay.
Say bye. A clipboard.
No, it's not. Oh, yeah, one right there. Okay, now I'm getting ready to go over that paperwork on the clipboard with you. That first document should be titled Judge's Explanation of Rights to Defendants Without Attorney. And the document looks like this, okay? I will constantly refer back and forth to this document as I explain everything on this document and the other documents that's on the clipboard. Okay, now, this document states that as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire your attorney. Number two, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Okay, now, if you want an attorney to represent you and you have enough money to hire an attorney, then your case will be reset. Reset means that you'll be given another court date to give you time to hire an attorney. And the next one sentence paragraph below number three, the second one sentence paragraph below number three says that if you want an attorney but you cannot afford to hire an attorney, you may request that an attorney be appointed to represent you. Now, before you can get an attorney to represent you, you have to first fill out a financial questionnaire. The financial questionnaire is a 3-page document that is also on the clipboard. Now, this is only for people who will be applying for a court-appointed attorney. If you're not asking for a court-appointed attorney, you don't have to worry about this form. And the form, the financial questionnaire is titled Judge County Affidavit of Injuries, or it may just be titled Affidavit of Injuries. You'd have to fill out the entire first page, and then you will go to the second page at the top where it says Defendant's Oath. You'll fill out the top portion, and then you'll fill out the middle portion that is titled Unsworn Declaration by a Defendant, and then you'll stop. Okay? Now, this is only for individuals who will be applying for a court-appointed attorney. So if you're not applying for a court-appointed attorney, you don't have to fill out this document. Now, the third one sentence paragraph, I'm referring back to the first document, judge's explanation of rights to defendants without attorney. The third one sentence paragraph below number 3 is for individuals who will be representing themselves. Now, if you're representing yourself, that simply means that you are waiving your right to have an attorney, you're giving up your right to have an attorney, you'll be representing yourself. And if you're representing yourself, you'll have an opportunity to talk to the prosecutor that is in court today. Now, the prosecutor is an assistant criminal district attorney who works for Jefferson County District Attorney's Office. We have Attorney Samuel Masradian. He's here this morning. So individuals who will be representing themselves will have an opportunity to talk to them. But you cannot talk to the prosecutor about your case unless you first sign a written waiver of your right to be represented by an attorney. Now, the written waiver is another document that is also on the clipboard. It is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. This is only for people who will be representing themselves. So if you're not representing yourself, you don't have to worry about this document. Okay? So those individuals, wherever individuals will be representing themselves, you have to read this entire page, and then you will sign and date it. Okay? That's only for people who will be representing themselves. All right. Now, referring back to the first document, judge's explanation of rights to defendants without attorney, there's a paragraph in block form, and this is for individuals who will be representing themselves, and it states that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing, government benefits, child custody, immigration status for non-citizens, and employment. Now, if you are representing yourself, this last paragraph, or this last one sentence paragraph at the bottom states that you may change your mind at any time and request that an attorney be appointed to represent you. So, for example, let's say you're representing yourself, you decided that you want to represent yourself, and you want to see whether or not the state will give you, let's say, a fine plus court costs. You talk to the prosecutor say, no, we're gonna offer probation. And you say, well, I don't want probation. But you can say, well, Judge, I changed my mind. I would like to apply for a court-appointed attorney. You can do that. All right. Now, at the bottom of this document, it states in bold letters, defendant's choice. Okay, I'm referring back to this first document there. Now, everybody is going to make a choice on this document. In bold letters, it says defendant's choice, marking issues to only one choice. If your choice is to hire your own attorney, then you'll place your initials on the first line to the left. And then you'll sign at the bottom where it says defendant, today's date, June 23rd, 2026. And this is the only form that you would have to sign. You will stop. If you have already hired an attorney to represent you, then you'll place your initials on the second line to the left. The second line at the bottom. And then you'll write the name of the attorney on the line to the left. And then you'll sign the bottom of this document which says defendant, dated, today's date, and then you'll stop, and this is the only form that you would have to sign. Now, if you would like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left at the bottom, sign this form, date it, and then you'll go to the affidavit of issuance or Jefferson County affidavit of issuance, fill out the entire first page, as I mentioned to you earlier. Go to the second page, fill out the top portion that is titled Defendant's Oath, and you'll fill out the middle portion that is titled Unsworn Declaration by a Defendant, and then you'll stop. If you have already been appointed a court-appointed attorney to represent you in this case, then you'll place your initials on the fourth line to the left on this form that is titled Judge's Explanation. And then you will sign your name on the line that's titled Defendant, date is today's date. And also, if you have an attorney that has been appointed, you'll write their name on the line to the left on under number 4. Okay? And then this is the only form that you would have to sign, and then you'll stop. If you would like to represent yourself, that is, waive your right to an attorney, or give up your right to have an attorney and represent yourself. Then you'll place your initials on the 5th line at the bottom to the left, sign that says on the line that's titled defendant. You would date it today's date, June 23rd, and then you go to this document that is titled waiver of counsel for purposes of entering a guilty plea or proceeding to trial, and you fill out, you read this document, sign it and date it, and then you'll stop. Okay, we have any questions? Anybody have any questions? No questions, okay. Now, I'm gonna give you time to fill out that, you have a question? Oh, I thought you was waving your hand. Okay, I'm going to give you time to finish filling out the paperwork. But the next thing we need to do, I need to tell you about some rights that you have. Now, you can, you have a right to enter a plea of not guilty. If you enter a plea of not guilty, you tell the court that you did not commit the offense that you've been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you tell the court that you committed the offense that you've been charged with. Or you can enter a plea of no contest, which means that you will not be fighting or you will not be contesting the charge. Now, if you're in a plea of not guilty, or, well, first of all, everyone has the right to have a trial by jury. Okay? That area over there where those 12 chairs are, we call that the jury box. Because we're in county court and law, 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all the evidence that's presented by the state, by the defense, the arguments of the state defense, and then they will go back into the jury room to deliberate. And they can either find you not guilty or guilty. You can also waive or give up your right to have a jury trial. If you waive or give up the right to have a jury trial, that simply means that you would not be having a jury trial. You still can have a trial. A bench trial is a trial, what somebody call it a bench trial, is by the judge, and the judge sits on the bench. The judge will be the judge and the jury in the case. The judge listens to all the evidence that's presented by the state, by the defense, listen to the arguments of the state and the defense, and the judge will apply the facts to the law and decide to find you either not guilty or guilty. Now, you can waive and give up the right to have a jury trial, and waive and give up the right to have a bench trial. If you do so, that simply means that you enter a plea of either guilty or no contest. Now, if you enter a plea of guilty or no contest, that indicates to the court that you're trying to work out a plea bargain with the state. Now, there are 2 types of plea bargain. One is called an agreed plea bargain. The other type is called an unagreed plea bargain. And the difference between the two is that, one, you reached an agreement with the state. And, regarding the punishment in the case. And the other one, the unagreed, means that you still want to enter a plea, but you have not been able to reach an agreement with the state concerning the punishment. And so if that's the case, then the judge will set the punishment on an unagreed plea. So if you have an agreed plea bargain agreement, what's going to happen is the case, once you come to an agreement, then it goes before the judge. The judge can do one of 2 things. The judge can accept or reject a plea bargain agreement. If the judge rejects your plea bargain agreement, you have a right to withdraw your plea, which means you can take it back. So, for example, let's say you're in the state that's come to a plea bargain agreement. You wanted a fine and court cost. They offer a fine and court cost. It goes before the judge, and the judge says, you know what? I'm going to reject that plea. If the judge does that, you can say, well, judge, I take my plea back. And that's I withdraw my plea. I'm not entering a plea of guilty no contest because you rejected the plea. You have a right to withdraw your plea if the judge does not follow. Now, if the judge does follow the plea bargain, and let's say within 30 days of the plea, you decide, you know what? I think I've been wrongly convicted, or the court committed error by convicting me. I'd like to appeal my case. If that's the case, then you have to get permission to appeal your case from the judge. The judge just follows the plea bargain agreement. Now, if the judge gives you permission, what's going to happen? The case is going to leave this court, and it's going to go right upstairs to the Ninth Court of Appeals. The Ninth Court of Appeals, there are 4 judges that's on the bench, and they will review your case. They can do 1 or 2 things. They can grant or deny your appeal. Now, if they grant your appeal, they can just simply find you not guilty, case over. Or they can send the case back down to this court with orders. Order this court to give you a whole new trial. Now, if they deny your appeal, you can appeal your case to a higher court than the Court of Appeals. You can appeal your case to the Texas Court of Criminal Appeals, which is located in Austin, Texas. And you would have to file what is called a pro se petition for discretionary review. I'll explain it to you. Pro se means self. In essence, you don't have a lawyer you represent. You're petitioning the court to review your case. To review your case to see whether or not your appeal should have been granted, or whether or not this court committed an error or this court wrongly convicted you. They can do 1 or 2 things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down here with orders. Now, if they deny your appeal, then at that point, your conviction will stand. Okay, now, you also have a right, I mentioned to you earlier, if you had an unagreed, you have an agreed plea bargain, you have an unagreed plea bargain, when y'all can't come to an agreement, then the judge will decide what your punishment would be. The judge can set punishment anywhere within the punishment range. Okay, now, you also have a right to have witnesses that come to court. That chair that has the microphone in front of it, we call that the witness stand. And what witnesses do, they'll come and testify. They can testify for you, against you. If you have a lawyer, your lawyer can ask some questions, or you represent yourself, you can ask a question. We call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses. What that means is you will not be calling witnesses. Does not mean that the state will not be calling witnesses, because they will be calling witnesses in your case. And you also have what is called a Fifth Amendment right against self-incrimination. What that means is this: Fifth Amendment of the United States Constitution gives us the right to remain silent. That simply means that the state, the government, the district attorney's office cannot call you to the witness stand to testify if you invoke or exercise your Fifth Amendment right against self-incrimination. Now, you can waive or give up your Fifth Amendment right against self-incrimination. And if you do so, then that simply means that you will be testifying. I know a lot of times we watch television, we see these television lawyers go up to the witness stand and ask the witness, to ask them a question. And the witness say, I take the fifth. In essence, they're saying, I'm not saying that I'm exercising, I'm invoking my Fifth Amendment right against self-incrimination. And if you think about it, it makes sense for us to have a Fifth Amendment right. And the reason why it makes sense is because of this. First of all, the state has the burden of proof. The state has to prove that you committed the offense beyond a reasonable doubt. Okay? You do not have to prove your guilt. Okay? You have the right to remain silent. You don't have to say anything if you decide to invoke your Fifth Amendment right against self-incrimination. Now, the other right I need to talk about is your right to have discovery. And what discovery is, it just simply means that you have a right to see the evidence that the state has against you. In essence, the state has a file, the state has witness statements. The state has witness statements, your statement, if you gave a statement, police reports, lab reports, video recordings, audio recordings, photos, documents, instruments. They have all of that evidence. You have a right to have access to that evidence. It's called discovery. Now, you can waive or give up your right to have discovery. If you waive or give up your right to have discovery, that simply means that you will not be having access to the evidence that the state will be using against you in your case. Okay. Now, everyone here, for a case, you have a charge filed against you. You've been arrested, placed in a county jail. You're out of jail on bond. You get out of jail on a cash bond, which means you pay a full amount of the bond to get out of jail. You're out of jail on a surety bond, which means that you pay the bondsman a percentage of the bond to get out of jail. or you're out of jail on what is called a PR bond or a personal recognizance bond. Which means that you're not paying money to get simply released under your own personal recognizance. I say that to say this. Every day that you spent in jail can be used as credit toward your punishment. Now, the operative word is every day, okay? And I'll explain that to you. Let's say you were booked into jail at 11:59 p.m. on last night. And then you booked out of jail 2 minutes later at 12:01 a.m. this morning. That's 2 days. You get credit for 2 days. Why? Because yesterday was Monday and today is Tuesday. Okay? And so that's 2 different days. And so you was in jail 2 minutes, but you get credit for 2 days because it's 2 different days. All right. So I've said that to say this. Every day that you spend in jail can be used as credit towards your punishment. So for example, let's say you talk to the prosecutor or the attorney talk to the prosecutor. You serve 5 days in jail, they offer you 5 days in jail. That means you will not have to spend any more time in jail. Why? Because you'll be given credit for the time that you've already served, the 5 days. Now, if they offer 7 days in jail and you spend 5 days in jail, that simply means you have to serve 2 days in jail. Why? You already have 5. We subtract 5 from 7 and leave 2. Now, yes.
Isn't it like a 3-1 or something like that?
That's up to the sheriff.
Okay.
Yeah, we don't have any control of that. The sheriff can give good time credit and trustee credit. They can give all that. All right. The other thing is, if the state is offering fine and court costs, right? Every day that you spent in jail, you are credited at $100 per day. So in my scenario, if you spent 5 days in jail, that's $500 that can be used toward your fine and court costs. So if they offer you fine and court costs of $500, that simply means you don't have to pay anything. Why? Because the 5 days that you spent in jail has already paid it off. Therefore, it will be taxed every time. Now, if they offer fine and court costs of $700, you spent 5 days in jail, which is $500. We take 500 from 700, that leaves 200. That means you would have to pay 200 on the day that the case is disposed of. Now, if you can't pay it, no problem. Why? Because we can put you on what is called a payment plan. And so you can pay off in small monthly installments until it's paid off. Now, let's say you do not have the income to pay it off on a payment plan. No problem. We can convert the fine and court costs to community service. So for every 1 hour of community service that you perform at a nonprofit organization, $12.50 will be credited toward your fine and court costs. So for example, in our scenario, you owe $200. If you work 8 hours one day doing community service, that's $100 that will be credited toward your fine and court costs. So in our scenario, you work 2 8-hour days, you paid off the $200. Okay. Now, Jefferson County has a program for first-time offenders where they would dismiss the case and you can get it wiped off your record. All right. The program is called pretrial diversion. With pretrial diversion, in order to qualify for pretrial diversion, it has to be your first time having 1 or more cases filed against you. Okay. And you have to have an attorney to get you into the program to help you with the application process. And it cannot be an offense for unlawfully carrying a weapon or resisting arrest. Okay. Now, if you qualify, you get into the program, you complete the program, the case is dismissed, then you can get it expunged, which means wiped off, erased, or deleted from your record like it never happened. Okay. If you are a veteran of any one of the branches of the military, Jefferson County District Attorney's Office has another program that is called Veterans Court. It's for veterans only. Only thing you have to do to get in the program is to be a veteran. You get in the program, complete the program, they dismiss the case, you can get it wiped off your record. Okay. Now, Jefferson County, and also part of the pretrial diversion program is something that's called BIP, Batters Intervention and Prevention Program. This is the acronym BIP, Batters Intervention and Prevention Program. What that program is for individuals who have assault cases involving family violence. You get into that program, you go through the VIP classes, they dismiss the case, you can get it erased from your record or expunged from your record. Also, if you have just an assault case, there's a program called anger management. With anger management, you go through the anger management classes, complete those classes, they dismiss the case, you can get it expunged, which means erased, deleted, or wiped off from your record. All right. Now, this court, County Court at Law Number 2 of Jefferson County, Texas. There's a program that God led me to start within the first 100 days of taking office. The program is known as the CSI program. CSI stands for Community Safety Initiative. With that program, the program is designed to address the issue of what we call recidivism, when people commit crimes over and over. And the way we address it is through partnerships that we have with various agencies in our community. Now, we have a partnership with Spindletop Center. Spindletop is our local mental health center in our Southeast Texas region. And they have the expertise to handle individuals that have mental health issues. So they have doctors, counselors, mental health officers, and a whole host of individuals who have expertise in mental health. Now, in order to participate in the program, you do not have to be incompetent or insane. You can just merely suffer from depression or anxiety or any host of mental illnesses, and they have the expertise to address your issue. Now, what they will do, normally they're here on Tuesday, they're not here today, but they're normally here. What they normally do is they can conduct a private interview, either in our jury room at their facility, by telephone or by text, whichever is convenient for you. They will do an assessment to determine what your mental health issue is. And then they will develop a treatment plan for either outpatient or inpatient treatment. Now, if you have an issue with drugs or alcohol, well, they have a program, Spindletop that is, has a program that's called ATAR. ATAR is an acronym, ATAR, that stands for Addiction Treatment and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OSAR, OSAR, that stands for Outreach Screening Assessment and Referral. Both ATAR and OSAR are alcohol and drug recovery programs, and what they will do, they can do a private screening, which is an interview. They can do an assessment to determine what your issues are with drugs and or alcohol, and they can develop a treatment plan for either outpatient or inpatient treatment. If you do not have a job, or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. That is an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry and the shipping industry and the chemical industry. Once you are trained in one of those areas, they will help you to get a job in the area that you're trained in. Now, if you have not graduated from high school, if you do not have a GED, they have a GED program. And Spindletop also has a GED program. And they will help you to get your graduate equivalency diploma. Now, all of the programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this court, we don't just give time. We take out time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to County Court at Law Number 2 in Jefferson County, Texas, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs that I just mentioned to you, just let us know. And we can direct you to individuals that you need to talk to so that you can get on the road to living your best life. Now, as I mentioned to you earlier, the paperwork that you have, we're going to pick that paperwork up from you. We're gonna put you into one of three categories. One category is you wanna hire your own attorney. And if that's the case, your case will be reset today to give you time to hire an attorney. The next category is if you have, if you like to apply for a court-appointed attorney, then we'll look at the application, make sure everything is filled out right, and if you qualify, an attorney will be appointed to you today before you leave. And the last category is if you would like to represent yourself, then we're gonna make sure the paperwork is filled out properly, and then you'll talk to a prosecutor. If you're able to reach a plea bargain agreement, your case probably will be taken care of today before you leave. Now, we're gonna pick up paperwork. If you need any help with the paperwork, we have our co-personnel, including myself, who will be helping you to finish filling out the paperwork properly. And once all of that is done, we're gonna call you up, as I mentioned to you, one at a time. If you need to use the restroom, there are two restrooms right outside in the hallway. The main restroom is front of County Code 11-3, which is right next door. The women's restroom is on the opposite side of the hall in front of the 172nd District Court. And now you'll be allowed to use the restroom. Please do, once you use the restrooms, please come back into the courtroom. Do not leave the courthouse. If you leave the courthouse, and if your name is called, and you're not here, then your bond will be forfeited. A warrant will be issued for your arrest. You'll be arrested, placed in the county jail. And then you're gonna have to bond out again, and guess what? You're gonna have to show up here for a arraignment, and we have to go through this all over again, okay? So we're gonna try to get you in and out of here as soon as possible. So make sure you conduct yourself accordingly. We are still in court, okay? And if you need help, just let us know and just raise your hand. And as I mentioned to you earlier, court person, including myself, will help you to fill out the paperwork. Okay, just hold on a minute, okay? So at this time, the court is gonna be in recess. You have a case.
Yes.
Okay, okay. Okay.
Right.
Mr. Lawrence, the Stacy Lawrence, Mr. Lawrence.
Yes, ma'am. I mean,
Okay, now,
sure.
Mr. Lawrence, your case will be reset. We understand that you've been hospitalized, so your case is gonna be reset to July 28th of 2026.
That's my
At ni-
birthday.
Okay, at 9 a.m. Okay,
Uh,
July 28th.
July 20th.
Oh, July 28th, 2026 at 9 a.m.
Gotcha.
And your reset will be sent to your bondsman. Stay in contact with your bondsman. Also, I need to give you some bond conditions. I'm going to read these bond conditions to you, and your bondsman is going to get a copy of these bond conditions as well. The document that I'm reading is titled Standard Bond Conditions in County Court at Law Number 2, and it states as follows. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yeah.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yeah.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Mr. Lawrence, did you understand that condition?
Yeah.
All right. Now, condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer, as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yeah.
And hold on a minute. Okay. So those are the conditions. Again, your bondsman will be given notice of these bond conditions. And once you, again, your case is reset to July 28, 2026. Okay? You're free to go and you have a blessed
Gotcha.
day. Mr. Lawrence, you're free to go and you have a blessed day. All right. Jefferson County Court at Law Number 2 is back in session. The court is in session with the arraignment docket. First case is Andrew Roy. Mr. Roy, would you please come forward? Right here in front of the bench. Mr. Roy, would you please raise your right hand? Mr. Roy, do you swear affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Roy, you may put your hand down. How are you doing, Mr. Roy? I'm doing fine, thanks for asking. Mr. Roy, your full name is Andrew Joseph Roy Jr.?
Yes, sir.
Okay, Mr. Roy, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you would like to have your case reset to hire your own attorney?
Yes, sir.
Mr. Roy, before you signed and initialed this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Roy, I read your answers. Your case will be reset to give you an opportunity to hire your attorney. But before your case is reset, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. I'm going to go over this document with you. And it states, Standard Bond Conditions in County Court at Law Number 2, following return of a criminal information in County Court at Law Number 2. Hold on a minute, yeah. This one is wrong. Why don't you get that back to me? I need the white out.
Wrong person?
No, it's the right person. I just need the white out. It's here. I have. Okay, now, Mr. Roy, the document that you have before you is titled Standard Bond Conditions in County Court at Law Number 2. And it states that as a defendant in a case, you have 3 options. Well, it states that following return of a criminal information in County Court at Law Number 2, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? Now, condition number 3 and 4 do not apply. However, condition number 5 on the next page does apply, and condition number 5 states, defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engage in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Okay, now if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? So you cannot possess any firearm or ammunition. The condition number 5. Okay, now have a stand in front of the court coordinator, follow her directions. Once you're finished following her directions, you're free to go, and you have a blessed day.
Thank you. Yes.
And you're free to go. Javier Rico. Huh? Huh? Oh, she's gonna be last. Yeah, okay, sir, don't lean on the bench. Do not lean on the bench. Okay. Now, Mr. Rico, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Mr. Rico?
Good.
You doing
Yes,
good?
sir.
And your full name is Javier Rico?
Yes, sir.
Now, Mr. Rico, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? Do you recognize this document? On page 2 of the same document, there's a set of initials above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Now, Mr. Rico, before you sign and initial these documents, did you read the documents? Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Rico, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Lori Perazzo. Attorney Perazzo will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you're free to go and you have a blessed day. Please stand in front of the court coordinator. Okay, have a seat in that first chair on the wall. Deron Dwight Patterson. Okay, Mr. Patterson, your full name is Deron Dwight Patterson? Mr. Patterson, would you please raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Patterson, you may put your hand down. How are you doing, Mr. Patterson? That's good, Mr. Patterson. I have before me two documents. First document is titled Jefferson County Affidavit of Indigence. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
Or these your initials on the line that state you like to apply for court-appointed attorney? Next document is titled Jefferson County Affidavit of Indigence. Do you recognize this document? And on page 2 of this same document, there's a signature above the line that is titled defendant. Is this your signature? Now, Mr. Patterson, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Patterson, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Albert Price. Attorney Price will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. Have a seat in that first chair on the wall.
If somebody's more serious though, as soon as 20, you should be contacting me within 24 hours at the number you gave.
Takia Kennedy.
Any questions before that? Thank you.
How are you doing, Ms. Kennedy?
Kennedy,
How are you doing? You doing all right?
yes, sir.
Okay, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, you may put your hand down. I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant? And are these your initials on the line that state you like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of this same document, there's a signature above the line that is titled Defend the Signature. Is this your signature?
Yes.
Now, before you sign and initial these documents that I'm showing you, did you read the documents? Do you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Marva Provo. Attorney Provo will be given information to contact you, and you will be given information to contact her.
It should be good.
Our court coordinator is going to give you that information. Once you get that information,
It's there.
you'll be free to go. You have a blessed day. Please have a seat in that first chair on the wall. Zanab Ali. Your full name is Zanab Ali? Okay, Miss Ali, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Miss Ali, you may put your hand down. How are you doing? I'm doing fine, thanks for asking. Miss Ali, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you would like to apply for a court-appointed attorney?
Yes, sir.
I have another document before me. This document is titled Jefferson County Affidavit Images. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there is a signature above the line that is titled Defend the Signature. Is this your signature?
Yes, sir.
Now, Miss Ali, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Miss Ali, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Nathan Reynolds. Attorney Reynolds will be given permission to contact you, and you will be given permission to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And let me do this here. Before she gives you that information, the bailiff is going to give you some bond conditions. And I'm going to go over these bond conditions with you. And it states, the document that you have before you states standard bond conditions in County Court Law number 2. And it states as follows. Following return of a criminal information in County Court Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Condition number 3 and 4 do not apply. However, condition number 5 does apply, and condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time paid employee of a state agency or a political subdivision. Do you understand that condition?
Yes, sir.
Now, if you violate any one of these conditions, your bond will be revoked, a warrant will be issued for your arrest, and you'll be placed in the Jefferson County Jail. Do you understand? Okay,
I keep this thing.
that's yours. You can have a seat in that second chair on the wall and wait for your name to be called. You're welcome. Is that Cushman Roberts?
His name is Mark.
Is that right?
She was first. She should be done with me.
Did I pronounce your first name right?
No, sir. Cashman. Cashman.
Tajman? Okay, I'm doing all right. Now, Mr. Roberts, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Roberts, you may put your hand down. How are you doing?
I'm doing all right.
That's good. Now, Mr. Roberts, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. All right, okay. And do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
Or are these your initials on the line that state you like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indians. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Now, Mr. Roberts, before you signed and initialed these documents, did you read the documents? Do you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Roberts, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in your case is Attorney Charles Rojas. Attorney Rojas will be given information to contact you, and you will be given information to contact him. Our court coordinator is going to give you that information. Ma'am, that door is locked. That door, you gotta go through the other door. And once you get the information from our court coordinator, you're free to go and you have a best day. Sierra Tompkins. Ms. Tompkins, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Tompkins, you may put your hand down. How are you doing, Ms. Tompkins? I'm doing fine, thanks for asking. Ms. Tompkins, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
There's a set of initials on the line that is titled, well, that states you like to apply for court-appointed attorney. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled Jefferson County Affidavit of Indians. You place your signature on page 2?
Yes, sir.
Now, before you sign and initial all of the documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Tompkins, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Sure. And once she gives you that information, you're free to go and you have a blessed day. Please have a seat in that second chair on the wall. Benjamin Jennings. Mr. Jennings, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing, Mr. Jennings?
Good.
I'm doing fine, thanks for asking. Excellent. Mr. Jennings, I have before me two documents. The first document is titled Jefferson County Affidavit of Indians. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials on that the top above the line that is titled defendant signature, is this your signature?
Yes, sir.
I also have another document that is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document?
Yes,
And is this your signature on the line that's titled defendant?
yes, sir.
And are these your initials on the line that state you'd like to apply for court appointed attorney?
Yes, sir.
Now, Mr. Jennings, before you sign and initial these documents, did you read the documents?
I did.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Jennings, I read your answers. Based on your answers, you meet the eligibility requirements of the appointment of a court appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Marcus Wilkerson. Attorney Wilkerson will be given permission to contact you, and you will be given permission to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day.
Sir.
All right. Cody Allen. Mr. Allen,
Yes, sir.
would you please raise your right hand? Mr. Allen, do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Allen, you may put your hand down. How are you doing, Mr. Allen? I'm doing fine, thanks for asking. Mr. Allen, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled defendant? And are these your initials on the line that state you'd like to apply for court appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And is this your signature on the line that is titled defendant signature? Okay. Now, Mr. Allen, before you signed any initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Okay, Mr. Allen, I need to ask you a couple of questions. I'm gonna take this Your attorney, well, first of all, you qualify for court-appointed attorney, and the attorney that will be appointed to represent you in your cases is Attorney Langston Adams. Attorney Adams will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Now, before she gives you that information, the bailiff need to give you I'm going to give you some bond conditions, okay? I'm going to go over these bond conditions with you in the states. Standard bond conditions in County Court at Law Number 2, following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 states that the defendant shall not communicate either directly or indirectly with the alleged victim of the pending case. And the victim in this case, hold on a minute, is LaShawn Griffin. And the defendant shall not go near any residence, school, or other location frequented by the alleged victim. You understand that condition?
Yes, sir.
Okay, now condition number 4 does not apply. Condition number 5 does apply. It states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
And condition number 7 does apply. It states that the defendant shall wear a global positioning monitoring system, which is a GPS device, at the defendant's expense, with written verification being submitted to the court within 3 days after the date. Do you understand that condition? Yeah, it's an ankle monitor. Okay. Now, if you violate any, if you don't get it, yeah, you have to get it. But if you don't get it within 3 days, you're in violation of this court order. Okay. Yeah, you have to get a GPS monitor. I'm telling you that they didn't have to. I'm giving you the bond conditions. Okay. That's a condition of your bond. And so while you're out on bond, on this case, you have to get a GPS. Okay. And you have to provide proof to the court within 3 days. So you can either bring it to the court, or you can get our email. You can get the email address from one of the clerks, or you can fax it, fax number. So either way, okay? Now, if you violate any one of these bond conditions, your bond will be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? Okay, Mr. Allen, do you understand? Oh, okay. You're gonna have a seat, wait for your name to be called. Here you go.
Who's mine?
That's yours. That's right. That root. Rayon Bruton? Rayon? How you doing, Ms. Bruton? I'm doing fine, thanks for asking. Ms. Bruton, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yeah.
Is this your signature on the line that's titled defendant?
Yes.
Or are these your initials on the line that state you'd like to apply before the appointed attorney? They have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes.
Now, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read? And is everything in these documents true and correct
Yes.
to the best of your knowledge? Okay, and I need to ask you some questions. Okay, Ms. Bruton. The court, you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Tom Burbank. Attorney Burbank will be given information to contact you. And you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you're blessed to have a seat in that first chair on the wall. Here you go. Serena Bobino. Yes. Let's see, your full name is Serena Lachey Bobino. Ms. Bobino, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing? That's good. Now, Ms. Bobino, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line as title defendant?
Yes, sir.
And are these your initials on the line that state you like to waive your right to an attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You recognize this document?
Yes,
And is this your signature on the line as title defendant?
yes,
Now, before you sign and initial these documents, did you read the documents? And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
yes, sir.
Now, Ms. Bobino, understand that you've talked to the prosecutor in your case?
Mhm.
Is that correct?
Yes, sir.
And Mr. Maserati? You talked to Ms. Bobino in her case?
That's correct, Your Honor.
Okay, and
At this time, we think it would be best to give the state more time to review the footage in this case and make sure we can come to a just outcome, and so we can reset the case to later determine what will be best.
okay, this case was an old case. This case was
Super old.
transferred from county court at law number 2.
That's why I keep wanting to say,
Okay, I'm gonna reset it. Well, it's gonna be reset, but I'm just gonna reset it a week. Okay, so this case is gonna be reset 1 week. Reset Ms. Bobino's case 1 week.
Yes, sir.
Remember a day, because I do have to do the baby, I don't have like a real daycare because of my child's.
I'm saying, see, the day is the 23rd, so it'd be the 30th.
It would be next Tuesday.
Okay. So the case will be reset till June 30th, 2020. Well, put it on I wonder if we ought to just put it on no, I was thinking about putting it on a Monday. Yeah, we'll keep it there. We'll keep it there.
Yeah, Monday will be a better.
Okay, we'll put it on the 29th.
Okay.
Okay. So we're gonna put it on the 29th. Okay, June 29th.
Yes.
All right. Her name is, she on page 2, the last one on page 2, Bobino. The 29th next week, Monday, okay?
I overheard you say you was a child support,
Yeah, child-
judge at one point.
No. I wasn't a child Okay, this is, the court is back in session and calls number 25 CCCR 2842, case style of state of Texas versus Dante Ramon Harris. Dante Harris was scheduled to be in court this morning at 9 AM. At about 9 AM, the court's bailiff called the name of Dante Harris at the courthouse door. Dante Harris did not answer. Dante Harris has not appeared in court since the court has been in session. The time now is 12:07 PM on today's date. Ms. Bailiff, could you please call the name of Dante Harris at the courthouse door? And today's date is June 23rd, 2026. Dante Harris' name was just called at the courthouse door. Dante Harris did not answer. Reasonable time has passed to give Mr. Harris an opportunity to appear in court. He has not appeared in court. State, do you have a motion? That motion will be granted. Dante Harris' bond will be forfeited and warrant should be issued for his arrest. And cause number 25 CCCR 2842. Who do we have next?
Saucedo.
Okay, next case is cause number 26 CCCR 0610. Case is style of state of Texas versus Salcedo Christian Montoya. Salcedo Montoya was scheduled to be in court this morning at 9 AM. At about 9 AM, the court's bailiff called the name of Salcedo Montoya at the courthouse door. Salcedo Montoya did not answer. The time now is 12:08 PM on today's date. Ms. Bailiff, could you please call the name of Salcedo Montoya at the courthouse door? Salcedo Montoya.
Saucedo Montoya.
I'm not gonna be there.
Okay, Salcedo Montoya's name was just called at the courthouse door. Salcedo Montoya did not answer. Reasonable time has passed to give Mr. Montoya opportunity to appear in court. Is not appearing in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Salcedo Montoya bond will be forfeited and warrant shall be issued for his arrest in cause number 26 CCCR 0610. Who is next is Prakash. Next case is cause number 26 CCCR 0622. Case is style of the state of Texas versus David Oscar Prakash. David Prakash was scheduled to be in court this morning at 9 AM. At about 9 AM, the court's bailiff called the name of David Prakash at the courthouse door. David Prakash did not answer. He has not appeared in court since the court has been in session. The time now is 12:09 PM on today's date. Ms. Bailiff, could you please call the name of David Prakash at the courthouse door? David Prakash's name was just called again at the courthouse door. David Prakash did not answer. A reasonable time has passed to give Mr. Prakash an opportunity to appear in court. He is not appearing in court. State, do you have a motion?
State moves bond forfeiture.
That motion will be granted. David Prakash bond will be forfeited and a warrant shall be issued for his arrest in cause number 26 CCCR 0622. Okay, quarter being recessed to 1:30.